looking at forest diversions. It's important to understand forest diversions in relation to the Environment Impact Assessment notification, because often mining operations, like any other industry, also would require it would probably require both forest and non-forest land. So if it requires both forest and forest land, a separate approval for diversion of forest land for non-forest use is required under the Forest Conservation Act. And there are very clearly defined steps under the Forest Conservation Rules, which were issued as part of the under the Forest Conservation Act of 1980, which are which have been modified also in 2014, and which very clearly lay out how what is the process to be followed when any user agency, public sector or private sector, requires the use of forest land for any mining operations. Some of the key steps are: a user agency, in the present case it would be a mining company or an individual, needs to submit an application seeking for diversion of forest land from the State Forest Department. And in particular, this would mean the Divisional Forest Officer, which is located closest to where the mine is going to be set up. The DFOs need to inspect the site, prepare a report based on series of criteria, and forward their recommendations on whether or not the forest should be given away for non-forest use. Based on the DFO's recommendations, the Principal Chief Conservator of Forests, in between there is also the Chief Conservator of Forests who will review the DFO's approval, and then finally goes to the Principal Chief Conservator of Forests, forwards the approval to the Ministry of Environment, Forests and Climate Change. This practice of the ministry giving prior approval for forest diversion was actually institutionalized through the Forest Conservation Act, which is in operation today. And this is when the central government had recognized that there is uncontrolled and unprecedented rates of deforestation in the country, and the state governments are not being able to manage it. That is also the history of the Forest Conservation Act. At the Ministry of Environment Forest level, there is also a Forest Advisory Committee which reviews the proposal and gives its recommendations. In the process of this review, the Forest Advisory Committee can call upon experts, make additional site visits, and seek any amount of additional information that it requires from the user agency. Based on the recommendations of the Forest Advisory Committee, the Ministry of Environment and Forests can either reject or approve forest diversion proposals. So the recommendations of the FAC actually are not binding. And there have been several instances where either the Ministry of Environment has agreed or disagreed. In this module, there are links to 2 or 3 such examples which you can study more closely to understand how this decision takes place. After the Ministry of Environment Forest decision, it is actually the state government which needs to issue an order invoking Section 2 of the Forest Conservation Act, and only then the forest land can be transferred to the user agency. So you cannot actually start operation on mining if you've just received final approval from the Ministry of Environment Forest. It only gets invoked with an order issued by the state government, and the state government has complete right on whether or not it agrees to or disagrees with the Ministry of Environment Forest. There are also related procedures which are critical to the forest diversion procedure. And these basically relate to compensatory afforestation, payment of net present value for the use of the forest land, and the monitoring aspect. All proposals for forest diversion need to do specific compensatory afforestation. They need to also deposit a very clearly calculated net present value for the diversion of forest land for non-forest use. These are what get deposited in a centralized compensatory afforestation planning and management authority fund. The details of this are again in the text of this module. The third set of approvals which are critical before us are wildlife related approvals. Believe it or not, actually some mining operations also start impacting wildlife areas. So, and these are protected areas like national parks, sanctuaries, community reserve, conservation reserve, which have been explicitly declared with restriction on human use for protection of wildlife. However, the construction of mine may involve the use of areas designated as national parks, sanctuaries, etc. For this, then the clauses of the Wildlife Protection Act 1972, later amended to 2002, which need to get invoked. In such cases, the project is referred to the National Board of Wildlife and a standing committee for approval under the Section 29 of the Wildlife Protection Act. Section 29 of the Wildlife Protection Act basically restricts any person from destroying, damaging, exploiting, or removing anything from areas protected for wildlife under this Act. Permissions may, however, be granted by the Chief Wildlife Warden. The procedure very clearly laid out under the Wildlife Protection Act says that mining cannot be granted unless the state government is satisfied in quotes, such destruction, exploitation or removal of wildlife from a sanctuary is necessary for the improvement and better management of wildlife. So a mining operation would need to be justified that it's not going to impact wildlife, if it's not going to, definitely not going to enhance wildlife, but it should not be destroying wildlife. In the case of wildlife sanctuaries, the procedure entails seeking the permission of the Chief Wildlife Warden of the protected area of a particular state where the sanctuary is located. However, the Chief Wildlife Warden has to consult the concerned State Board of Wildlife before the permission is granted. For national parks, the consultation needs to be with the National Board for Wildlife and its standing committee, which has been delegated several tasks under the law. In addition to the areas within the protected areas, if any project requiring environmental clearance is within 10 kilometers, and this actually has been recently amended to being 5 kilometers of a national park sanctuary or a community reserve or a conservation reserve, would need to get the permission of the National Board for Wildlife. So you might be outside a protected area but within 5 kilometers of a protected area, and you would need that permission. Very clearly, the National Board for Wildlife and its standing committee has a very important role to play. Prior to 2002, the National Board for Wildlife was actually referred to the Indian Board for Wildlife. Its composition and powers underwent a change in 2002 when the Wildlife Protection Act was amended. However, the National Board for Wildlife was only notified first in 2003, and its first meeting was held in December 2003. Like the IBWL, that's the Indian Board for Wildlife, the Prime Minister of India also chairs the National Board for Wildlife. The Wildlife Protection Act's amendment also stated that the National Board for Wildlife will have the discretion to constitute a standing committee to which it can delegate specific tasks and duties. In most cases, the standing committee does do the operational part of this task. Other than these laws, the Supreme Court of India has actually had a significant role to play in determining the use of forest land for non-forest use and and which has come and also looked at other aspects of the mining sector, where especially when forest lands are involved. For instance, if any mining project requires non-forest use of a protected area, it also attracts the provisions of 14/2000 order of the Supreme Court under the T. N. Godavarman case, which is Writ Petition 202 of 1995, an ongoing case in the Supreme Court of India, which has far-reaching consequences in determining the nature of forest management in the country. This order actually bans the removal of dead, diseased, or wind-fallen trees, driftwood, and grasses from any national park and sanctuary. So basically, if any mining operation does take place, it would require removal of these dead, diseased. It would have an impact on the protected area, and therefore, any activity in a PA that amounts to such removal entails to take the permission of the Supreme Court of India. So that actually Supreme Court, not just in the 14/2000 order, under the Godavarman case, has had several implications for mining projects, including renewal of temporary working permits, and especially when mining leases are yet to be renewed and forest clearances are required, and so on.